Today we're going to briefly describe the evolution of human rights in the 20th and 21st centuries. We're going to go on from there to talking about humanitarian intervention, and specifically to focus on the UN's responsibility to protect, or R2P. And we're going to distinguish between war crimes, crimes against humanity, and genocide. And this week we're going to debate whether the prevention and punishment of genocide should be a priority in developed countries' foreign policies. With regards to rights, Donnelly talks, of course, about human rights very broadly and gives you a fair amount of background on the subject. Human rights for Donnelly, and this is a very important point, are human rights due to their universality. Rights for a select group aren't really human rights at all. They're rights for a group. The key distinction is to focus on the questions of universality that Donnelly talks about, and especially on questions of human dignity, as opposed to development or justice and other things like this. Look through box 30.2 in chapter 30 of your textbook. Many of the rights enumerated are based on social factors, things like the right to a family life, the right to property, education, that you could materially function without, but that would perhaps not let you lead a life in the state of dignity that you might want to be able to lead it in. You should, of course, know the laws that constitute the International Bill of Human Rights and have a good general sense of the kinds of rights they cover. Boxes 30.1 and 30.2 are excellent guides here. During the Cold War, the geopolitics of the Cold War really minimalized attention to rights. And this continued in the 1950s and 1960s, with rights abuses being seen as normal in order to keep specific countries on quote-unquote our side in the Cold War. By the 1970s, this is beginning to change. First of all, news of human rights abuses in Nicaragua, Guatemala, El Salvador really starts to minimize a US-based and a first world-based human rights community and drives them to activism. Second, the election of Jimmy Carter, who promises a foreign policy that is based on a new level of concern for human rights. Then, the Tiananmen Square massacre in 1989, which focuses attention on human rights in a way that hadn't really been there before, especially as this comes not a whole long time before the end of the Cold War, and gets the United States putting sanctions on China until 1994. Finally, new applications of human rights to migrants and undocumented populations. Until the 1970s and early 1980s, migrants and people who are out of legal status were considered to have no real rights at all in the countries that they found themselves in. Well, from the late 1970s, the European Court of Human Rights, US and Canadian courts start to rule that people who are undocumented nevertheless possess a certain number of rights, and that their rights cannot simply be cast aside because they are undocumented. Well, all of this is going to help develop a new consciousness about rights and turn rights into much more of a serious political issue than they had been previously. By the late 20th and early 21st centuries, we have this growing body of human rights instruments, referred to by Donnelly as the International Bill of Human Rights. We have lots of INGOs, we have lots of NGOs, we have increasing transnational use of foreign jurisprudence in national courts. In Lawrence versus Texas and Atkins versus Virginia, two relatively recent U.S. Supreme Court cases, the U.S. Supreme Court referred to European Union law, briefs submitted by the European Union, in the reasoning of the majority and in the reasons provided for the decisions of the majority. Lawrence versus Texas pertained to Texas's anti-sodomy law that the court struck down. Atkins versus Virginia focused on the execution of people who are found to be mentally handicapped or developmentally disabled at the time that they commit a crime. What Donnelly points out is that we have a system of national implementation of human rights norms with modest international oversight, and with decidedly a mixed track record of success. In some cases, of course, the success has been very noticeable and very real. In other cases, not so much, and it hasn't quite necessarily reached the level that advocates of human rights like Donnelly himself would like to see. All of this, of course, is related to peacekeeping and humanitarian intervention, even though, as Donnelly is at pains to point out, these aren't quite the same thing. From the 1950s to the 1980s, peacekeeping fell under Chapter 6.5 of the UN Charter. It was not officially recognized as an activity by the UN Security Council. Nevertheless, it involved groups of soldiers sent to keep the peace in conflict zones and de facto authorized by the United Nations in order to do so. Well, in the 1990s, new humanitarian crises come up that really aren't well adapted to this older model of peacekeeping. In Mogadishu and in Srebrenica, you have situations where efforts to engage in humanitarian intervention don't quite work out the way they had been planned to. In Mogadishu, 18 US Marines get killed, it becomes a political disaster, and even though in reality the peacekeeping missions did a lot of good on the ground, it's not seen as politically viable anymore. In Srebrenica, of course, it's a disaster all around, both the Dutch peacekeepers guarding the town and the Muslim men and boys who are hiding in the town lose their lives. Well, since the early 1990s, the UN Security Council has expanded its list of what counts as a threat to peace, and has begun to reshape and recraft what humanitarian intervention means. And partly this is based on the view that sovereignty does not equal the power to do whatever you like. If we go back to the older view of international law was classically seen very much as a matter of maintaining order between states while letting governments more or less do whatever they wanted to their own people. That view has been progressively eroding since the humanitarian interventions into northern Iraq to construct no-fly zones in order to protect Kurds, and subsequently as a result of other efforts at humanitarian intervention, including the bombardment of Kosovo in 1999, and the more recent intervention into Libya. Now, of course, there are multiple arguments for and against humanitarian intervention, and your book pretty much gives you a nice breakdown of what these look like and what these are. You should know the counter-restrictionists, and you should know the restrictionists, and you should be especially familiar with what they say and what they have to offer, because it's going to help you engage the activity we're going to do next in the class. In order to do that activity, I have to now take a little bit of time to distinguish between three classes of crimes in international law: war crimes, crimes against humanity, and genocide, in order to then put Sarah Sewell's contribution to this debate into some perspective. War crimes are the crimes we've already talked about in this class. They refer to those crimes enumerated by the Geneva Conventions, usually covered by the term jus in bello. All of the issues that we talked about regarding the treatment of prisoners and the treatment of civilians in warfare, that's what war crimes covers. Crimes against humanity are a set of 11 legal texts prohibiting mass murder, extermination, enslavement, torture, and rape, among other things. Both of these, though, are different from the crime of genocide. Genocide is distinctive for two separate reasons. First of all, it requires an effort to destroy individuals because they are members of a protected group. For example, destroying Muslims because they are Muslims, or destroying Armenians because they're Armenians. Killing, displacing, trying to prevent births amongst a group of people because you're trying to destroy the life possibilities or simply kill those members of that group because they are members of that group. Second, genocide requires intent. What makes the 1948 Genocide Convention different from other forms of international law on these issues is that you need to demonstrate the intent of the people carrying out the acts. One of the difficulties with the Genocide Convention is that it is incredibly difficult to apply. The Nazis were not convicted on charges of genocide. They were convicted on charges of war crimes and crimes against humanity. We have to get into the 1990s with the international tribunals in Rwanda and in the former Yugoslavia, in order to actually get to situations in which people are found guilty of genocide. The demands, the legal issues around genocide are complicated. And of course, in some ways, this is meant to be this way because you don't want to use an instrument like this too casually. On the other hand, it makes for a lot of indecision and a lot of difficulties in relation to knowing when and how to intervene into a conflict zone, and when in fact the activities going on in that place reach this threshold that prompt international action. The concept of R2P, the concept of the responsibility to protect, is in fact related in part to these issues and related in part to these kinds of questions. R2P focuses on the idea that the international community has a responsibility to protect people inside a given state, even when that state doesn't actually threaten its neighbors. This, of course, is a significant rereading of the UN Charter, which classically was understood to argue the opposite, that you only had the right to intervene when a state does threaten its neighbors. R2P is pretty well described in your textbook. It also entails, for example, R2B, the responsibility to rebuild, and most importantly, the responsibility to stick around for a while after a conflict has come to an end. Sewell and a number of other human rights experts, of course, are big fans of R2P, and are big fans of the idea that the prevention and punishment of genocide ought to be a central plank in developed countries' foreign policies. In other words, we ought to be reorganizing our foreign policies in order to make the human costs and the social costs and the economic costs and the environmental costs of genocide into an issue of capital concern. Obviously, this idea has incited a lot of debate, and not everybody agrees. And in the activity you're going to be doing this week, you're going to get to express and articulate and debate to what extent you do and you don't agree with the idea of making the prevention and punishment of genocide into a key foreign policy concern for the world's developed countries.